Yes, Mr. Hall.
My Lords, just a couple of minutes on ground 4, if I may. The first point is the profit share. I explained our position by reference to Mr. Bazant's written evidence that the royalty split demonstrates, and I quote, the expected additional profits that arise from the use of the IP. And I explained my case by reference to 100% patent. And my learned friend accepts that in that case, the licensee will take a share of the profit derived from the IP. But he says the case is different if it's not 100% patent. And I just want to consider that, because the 100% patent is a really strong and valuable patent. But on the evidence we've seen, the licensee will get about a 50% split of the profits from such a really valuable patent. That was the evidence of the experts, 25 to 50%, depending on the strength of the patent. So consider a different case where the licensee is able to contribute something above and beyond the invention to make more profit. Let's say 10%. So now the patent is a 90% patent. So it's less valuable than the 100% patent. The patentee expected to part with 50% of the value of the high value patent. We said, well, on what basis could it expect to retain all the profits from an inherently less valuable patent? And similarly, the licensee is entitled to a 50% share of the more valuable patent. So why would it not insist on a share of the less valuable patent? And we say, of course, it would. We say the same is true if it's an 80% or 50% or whatever. In any case, the patentee will accept that it needs to give away a share, and the licensee will expect that it takes a share. And so in every case, the uplift needs to be applied. And if one just considers the effect in this case, the figure that Mr. Bazant extracted from the 2014 agreement was 13%. I have my position that that should be uplifted to between 26 and 52. That adjusted figure then corresponds to the profits derived from the infringement. And Astronics and Panasonic get to keep the balance, which they say is attributable to all the other factors that owe nothing to the patent. So the method that I propose achieves the intended outcome in this case.
And it's rooted in the evidence, is it?
I beg your pardon?
It's rooted in the evidence, is it?
The fact that there would be that the patentee and the licensee would expect to split the profits 25 to 50%, depending on the value of the patent, is in the evidence, yes. I have the references in my skeleton.
And when you say profits, profits from what?
The profits, as Mr. Bazant said, the additional profits that arise from the use of the intellectual property.
Yes, but you're applying a percentage, whatever the percentage is, to a pot of profits. And what is the pot?
So one needs to consider whether we're looking at the license or the apportionment exercise, because the outcome, as I say, is that we've got between 26 and 52%, which represents the profits applicable to the infringement, and the remainder is the profits that owe nothing to the infringement.
But wouldn't that depend on the pot of profits to which you are applying the percentage, whatever it is? I mean, if it's the profits on a power unit, or an in-flight entertainment system, or a seat, or an aircraft, the percentage might vary, mightn't it?
Well, it might. And
it wouldn't affect the value of the patent, but it would reflect the contribution made by the patent to the generation of the pot of profits to which you are applying the percentage.
Indeed. But if in my hypothetical examples, if the patent is an 80% patent, for example, that value is still being split.
80% of what?
Of the profits of the enterprise.
But that's the very question that has to be answered, isn't it?
Well, indeed. And so if we have, in that situation, there's an 80% and a 20% split. There's 20% of the enterprise that owes nothing to the invention, 80% that does. And we share that 80% between us. My learned friend said that we didn't have the evidence for this case. We didn't advance this case below. We did lead evidence that the approach was fundamentally flawed, and we invited the judge to reject the approach on that basis. We say he was wrong not to do so. Now the question before you is one of practicality. What do you do in those circumstances? And we're simply seeking to alight upon a way to dispose of it without needing to go back to the judge. The Cipriani and Jack Wills cases, my answer to those is that the point that is before you now wasn't taken in those cases, and so the judges didn't have to consider it. I think I showed you that certainly in the Jack Wills case, only one of the experts, I think it was Mr. Bazant, gave evidence on that apportionment split. The other expert wasn't instructed to deal with it. And I think the position in Cipriani was that only one of the experts, only one of the parties turned up at the account, and Mr. Bazant, who was on the other side in that case, he turned up, but the judge elected not to call him because the defendant wasn't actually there. And then the final point taken against me is the point about the pleading. The critical point we say is that Mr. Ryan's evidence on the 1998 agreement, his 84% figure, was properly in reply. It was met with a further report by Mr. Bazant, and it was dealt with at trial on the substantive merits. There was no attempt by Astronics to have it struck out. The judge didn't foreshadow that he was minded to do so. And my learned friend submitted to you that the judge was entitled to accept or reject whatever evidence he liked. We accept that insofar as he was deciding evidence on the substantive merits, but we don't accept that proposition as a matter of procedure. He had to foreshadow that. My lords, unless there's anything further, I can assist you.
Thank you very much. Right, where do we go next? Is this the intro? No, we're doing the KID agreement next, are we?
Well, unless Mr. Purvis, no, I think it's KID next.
Right.
The KID issues start with Panasonic and Astronics' appeal relating to the judge's findings at 685 of his judgment that the license conferred by Lufthansa upon KID under the 1998 team agreement was what he called a sole license rather than an exclusive license. And your lordships would have picked up that that appeal on construction of the 1998 teaming agreement is a step in an overall argument which involves the following steps. So first, that since, when correctly construed, applying uncontested principles of German law, the 1998 teaming agreement provides for a license to KID that excludes Lufthansa from the acts, the profits from which were the subject of this account, namely those made from selling and supplying components of in-seat power supply systems. KID was an exclusive licensee in respect of those acts within the meaning of the Patents Act 1977. So that's the first step. Then, as is recorded at 68 of the judgment, KID asserted Lufthansa's patent against General Dynamics, claiming that it had, that General Dynamics had infringed what KID called KID's right of exclusive use. But KID and General Dynamics settled that dispute by way of a 2003 settlement agreement, in which KID covenanted not to sue General Dynamics or its customers under the patent, and warranted that the grant of the exclusive users' rights gave it an independent right to raise claims for infringement. Then the next step is, as is no longer in dispute, Astronics and Panasonic have the benefit of that covenant not to sue, and so consequently, because KID, as exclusive licensee pursuant to Section 67 of the Patents Act, had the right to bring proceedings for infringement and the right to claim the profits derived from the infringement, those profits need to be allocated between Lufthansa and KID in circumstances where KID had compromised its rights. The point arising under that last issue is that raised by Lufthansa in paragraph 2.2 of its respondent's notice, namely its contention that the correct construction of Section 67 is that the court has no power to take into account the exclusive licensee's share if an exclusive licensee's claim is settled pre-action, contrasting the position where there is no settlement. I heard last night that my learned friend no longer pursues paragraph 2.1 of his respondent's notice, which was directed at the argument that if the license was exclusive, then it did not cover the acts of the defendants. So all the arguments about the exclusive license not covering the acts of supply fall away. So I better start by addressing the standard of review that applies in respect of an appeal regarding the interpretation of a written contract applying foreign rules of construction. And there are a couple of key background points. The first key point is that the relevant principles of German law as to construction applied by the judge are not disputed on this appeal. I'm not attempting to overturn a finding of primary fact as to what German law is. And the second key point to emphasise is that the relevant German law is, as I've just said, that of construction. So the appealed issue involves the application of agreed law of construction in what is a judicial exercise, namely the process of interpretation of a written contract. And with that, can I ask you please to take the core bundle and turn up tab 15 and page 286. This is Lufthansa's skeleton in relation to this appeal. And there is a section there headed D's attack on the judgment. If you look at paragraph 40, please, you can see that in the last sentence, or the last two sentences, it says that the parties could have structured the 1998 teaming agreements or that course of dealings by reference to either a true or sole exclusive licensing regime. The judge's task was to decide which of those two options the parties had alighted upon in the 1998 teaming agreement. And then in paragraph 42, before Leach J, Mr. Justice Leach, the question was not one of law but of fact. And then in 43, they say, thus D's must do more than show that the judge ought to have come to a different conclusion or that the arrangement could work under an exclusive licensing regime. They have to prove that the judge's conclusion was outside the range of reasonable ones available to him on the evidence. So Lufthansa describes the threshold in terms that are akin to the test that might be applied in respect of an exercise of discretion or possibly even primary, attempting to challenge a primary fact. But so
this relates to inadmissible evidence that both sides adduce before the judge, because the function of the experts as to foreign law is to educate the court on the principles of foreign law, not to apply it to the interpretation of the agreement. Both sides were guilty of allowing their experts to trespass beyond that.
My Lord Justice Arnold has anticipated one of my submissions. May I try, please, to set out the propositions of law that I rely on in respect of the threshold that needs to be applied to this appeal. So, first of all, the correct approach generally to an appeal involving foreign law is as set out in Perry and Lopag, namely that there is a spectrum of cases in which the key variable is the extent of the ability of a judge and an appellate court to use their skill and experience in domestic law to ascertain the relevant rules of foreign law and apply them to the facts of the case. And second, and it follows from the first, it follows that there's a spectrum in the extent to which the first appellate court will be prepared to review and intervene. The third proposition is, as my Lord Justice Arnold has just explained, there's an appeal relating to the application of agreed or uncontested principles of foreign rules of construction to a written contract will lie at the end of the spectrum where an appeal court is able to review the judge's judgment and intervene if necessary, because it is well established that the role of an expert of foreign law is to prove the rules of construction of the foreign law, and it's then for the court to interpret the contract in accordance with those rules. And in carrying out that exercise, this court is, in my submission, bringing its own, any court, this court or the court below, is bringing its own legal judgment to bear. It's carrying out the same or very nearly the same process of judicial interpretation that a judge performs in any contractual interpretation case. And accordingly, this court is in as good or very nearly as good a position as the judge to form a view as to the correct interpretation. It may not be necessary in light of what my Lord Justice Arnold has said, but I had better...
By the inadmissible evidence.
I'm sorry, my Lord, I spoke
It
over
might
you.
be said that we're in a better position than the judge because we're not hampered by the inadmissible evidence that both parties put in front of him.
Well, my Lord, I'm going to attempt to advance my appeal without relying on the inadmissible evidence.
Good.
Is the interpretation of written contract according to German principles of interpretation a question of fact?
Yes, I don't go so far as to say that there is a split between the law being a question of fact and then the construction of it, applying that foreign law, being a question of law. I don't go that far, but it is a question that is very akin to being a question of law. I think if it's a question of fact, what the law is, then applying that law, even if it's a question of construction, I'm not going to go so far as to say it's definitely a question of law, my Lord.
But it's not a question of English law, that's the problem.
What it is certainly a question of judicial interpretation that is very akin to the process of construction of any document, whether under English law or otherwise. So it's a judicial process. Whether that's necessarily a question of law or not, I'm afraid is getting into arguments that I don't need to advance today. King and Brandywine, that is tab 100 of the authorities bundle. If I could ask you, I have it in a bundle 5.
Supplemental joint.
It's a supplemental. It's a tab 100. So this is in support of the proposition my Lord Justice Arnold explains. And if you have page 3381, this is paragraph 68, but the bit I'm interested in is on page 3381. And the sentence that begins, it is perhaps also important to remember that the role of an expert, unless the law is concerned with special meanings, is to prove the rules of construction of the foreign law. It's then for the court to interpret the contract in accordance with those rules. In other words, the view of the expert as to the meaning which would be given to, well, in that case, the word debris is not admissible evidence unless he's saying it has a special meaning. That, again, points to the Court of Appeal being entitled to review a question of construction simply being guided by the rules of construction of the foreign law, including the court's attitude to persuasive authorities. As you can see, the last sentence of that paragraph supports the idea that because it's for the court to construe a contract applying foreign law, simply being guided by the rules of construction, that is a reason for this court to feel able to intervene or being entitled to review question of construction if necessary. I should identify two aspects of German law that are not in dispute but which are relevant. The first is the approach to construction, which is agreed to be set out as set out by the judge in his judgment in the confidential bundle at page 358, paragraph 656. And the critical sentence is the second sentence. Professor Ann also accepted Professor Metzger's formulation that the decisive factor in the interpretation of a party's declaration is how a reasonable third party in the position of the recipient of the declaration would have understood the declaration in good faith, taking into account customary practices. So it's an agreed principle that there's a requirement to arrive at an objective construction, taking into account the requirements of good faith. The second aspect, could you take my skeleton now, please, so the core bundle. Tab 13. Tab 14, sorry, tab 14. Paragraph 13 of that skeleton, so page 257. This is a proposition of law set out by Lufthansa's experts, which the defendants accept. The principle of good faith is a broad principle which in general terms means that parties cannot argue for an interpretation that would be contrary to their behaviour when entering into the agreement. It seeks to ensure that the spirit of the agreement is upheld. In accordance with this principle, an interpretation is to be sought which takes appropriate account of the legitimate interests of both parties and meets the requirements of fair commercial practice. So the process of construction requires seeking an interpretation which takes appropriate account of the legitimate interests of both parties and meets the requirements of fair commercial practice. It seeks to ensure that the spirit of the agreement is upheld. Before we turn to the 1998 teaming agreement itself, there are, I think, one, maybe two undisputed background facts that need to be borne in mind. Could I ask you, sorry, I feel like we're jumping around, but back to the judge's judgment at paragraph 35 on page 22. Your Lordships will have picked up that on the same day as the 1998 teaming agreement, Lufthansa and KID entered into the 1998 purchase agreement, which is referred to in that paragraph 35. And I'm just going to this to show you that under that agreement, Lufthansa agreed to purchase the Sky Power system and KID was to be the supplier of the components of that system. And if you turn forward to the judge's judgment at 652, page 357, the purchase agreement is referred to again, and as the judge held there, it provides evidence that when the parties entered into the 1998 teaming agreements, they contemplated that either Lufthansa or a seat manufacturer would assemble and install the Sky Power system, and we've seen the components of which KID was to supply. And then lastly, if we turn forward again to paragraph 685 sub 8, which is on page 379, the judge records there Article 2 of the 1998 purchase agreement contemplated that KID would supply the components either to Lufthansa or to seat manufacturers. So, can we now turn, please, to the teaming agreement itself, which is confidential bundle. I think there's a divider B, but it's tab 2. And it's at page 389 of the bundle. Now, one of the slightly odd things about the judgments is that the judge never actually goes through the 1998 teaming agreement, explaining what he understands different parts to mean. But as we do so, the key points to take from it are how it allocates tasks between Lufthansa and KID, and secondly, in particular, that it allocates the task of selling components, and it follows in my submission their supply exclusively to KID. So if we start with the preamble, which is on page 391, the main paragraph of significance is that which reads LHT, that's Lufthansa, has developed a technical concept for a 110 volt AC in-seat power supply system, hereinafter referred to as advanced system. So there's no dispute that the reference to the technical concept is a reference to the concept covered by the claims of the patent. And we can see that advanced system is being used, if you like, as a shorthand for the concept covered by the patent. And I believe that's also common ground. So we have the advanced system. Article 1, scope. KID will, under its sole responsibility, introduce the advanced system to the market. The parties agree that this responsibility comprises the development, the manufacturing, the marketing of, and the after-sales support for the said system. And then it said, Lufthansa will participate in the revenues resulting from such activities of KID. And if you just turn forwards to Article 5, where it deals with that participation in the revenues, Article 5, commercial conditions, the participation of Lufthansa in the returns of the sales of the advanced system will be based on the following principles, and then it sets out some terms. So Article 1 and Article 5 together make clear that it's KID that's doing the selling, and it's paying a license fee to Lufthansa. Lufthansa's participation in KID's activities is in the way of the revenues and the royalty stream from the revenues. So in respect of Article 1, I've got two submissions so far. The first submission is that it's establishing, in respect of the activities addressed in Article 1, what Lufthansa on the one hand and KID on the other will do. So as between Lufthansa and KID, it's KID that will carry out the activities listed, not Lufthansa. KID will be doing the manufacturing, the marketing of, which must include selling, and the after-sales support for the system. And Lufthansa is going to be participating in such activities of KID. That division fits with the fact that it was contemplated when the parties entered into this agreement that KID would supply the components to Lufthansa or to seat manufacturers. Second submission is that because there has to be revenue production for Lufthansa to participate in, as I've said, marketing here must mean selling the components. It's components because we saw it was contemplated that KID would be supplying components, and as we'll see in a moment, it's recognised that there needs to be installation. So KID's going to be doing the selling and also the supply, not Lufthansa. And as I mentioned, Lufthansa no longer presses its case in its respondent's notice that if this license is exclusive, then the scope of the exclusivity covers the act of supply. So all of the arguments in my learned friend Skeleton about how it was envisaged that Lufthansa would also need to supply under this agreement are no longer pursued. can I just make that good by just showing you, keep if you can, please, the teaming agreement open, but if you could also take the core bundle at tab 15 and just turn up page 295. This is Lufthansa's skeleton. And at 75.1, you see the argument that it's no longer pursuing, that given the customary practice of maintenance and repair operators, I think, taking possession of components next work, blah, 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 it was implicit that Lufthansa would sometimes be responsible for supplying components to their destination. That's not pursued anymore. So back to Article 1, please. And in fact, turning on to Article 3, because we've done Article 1. System installation. Do your lordships have that? We're on page 393 of tab 2 of the confidential bundle, Article 3, system installation. The first thing that this article does is it imposes a cooperation obligation on KID. And that is to recommend Lufthansa to any potential buyer for components for the installation of the systems. And then it continues, in principle, within this context, Lufthansa may offer the following services. And it explains what those services are, and they're the installation services, installation kits, and certification supports. And it explains that in such a case, Lufthansa will place and offer such service in its own name. And so if Lufthansa is going to do the installation, what we see is KID will supply it with the components for installation, and if the customer chooses a different installer, then obviously KID will supply that installer instead. So far what we've seen is an agreement that, although it involves cooperation, within the framework of that cooperation, the two parties have different roles. KID is going to develop, manufacture, market, and provide after-sales support. There's an obligation on KID to recommend Lufthansa's installation services, and the installation will be by Lufthansa or a different installer.
What is it that KID is going to make? Anything that falls within the claim?
Anything that falls within the advanced system, which is the concept that is covered by the patent.
The post-characterising bit, is that what you mean?
I think it's probably envisaged that it is a complete system, sorry, not with the parts joined together, but an ISPS that implements the patent.
And it's up to KID how it does it, or what else it includes.
Well, it has obviously has a license under the patent, but to the extent that it needs to include ground fault interrupt or other technology, then that's for KID.
Right, and so when you get to Article 3, the recommendation to a potential buyer, I mean, I assume the potential buyer is British Airways or somebody like that,
yeah.
Who want to install seats within flight entertainment systems, and KID undertakes to recommend Lufthansa.
We'll supply and sell you the system, components, and we have Lufthansa who are ready, and we recommend them as the installer. And if you don't like Lufthansa, for whatever reason, Lufthansa's price for its installation services or whatever, then KID is free to recommend or go with somebody else. Article 4, promotion. This is simply promotion campaigns. It makes clear that both parties are entitled to promotion. And in my submission, there's nothing in Article 4 that undermines the idea that KID will be the only party selling and supplying the components to either Lufthansa or another installer, and that Lufthansa will be offering its installation services and, if selected, assembling and installing the components. Article 5 we've already looked at, and then we need to turn to Article 6, which is the grant of the licence. patents intellectual property rights. The parties agree that Lufthansa remains the owner of the intellectual property rights concerning the advanced system, for which Lufthansa grants the KID an exclusive user's right in return for the payment of royalties, as stated above, for as long as this agreement is in force. My first submission is that the words advanced system for which Lufthansa grants to KID an exclusive user's right is a grant of a license to the necessary intellectual property rights, the rights concerning the advanced system, the technical concept covered by the claims of the patent. So it's a grant of a license concerning the invention in the patent, and I think that is common ground. The second is that this is a license in respect of the activities that we've seen in the preceding articles for which KID needs a license. So a license that covers selling and supplying. Third, it's common ground that this is a license at least to the exclusion of third parties, so at least a sole license. But the defendant's contention is that it's also to the exclusion of Lufthansa for the activities allocated to KID. The submission is that when it says exclusive, it means exclusive of Lufthansa. We've seen that KID is going to be developing, manufacturing, marketing, and that Lufthansa is, if selected by the customer, going to be installing. And we saw the background facts about what it was envisaged. It was envisaged that KID was going to be supplying the components. The submission is that it's not envisaged within this agreement that Lufthansa is going to be selling or supplying components. And as I understand it, from the fact this point's been dropped, Lufthansa no longer contends that it is so envisaged. So, I turn now to the judge's errors. I'm going to take them slightly out of order compared to my skeleton.
When we have an English law contract, parties in this court spend a lot of time telling us why the judge was wrong, whereas the fundamental question is what's the right interpretation?
Well, I've attempted to take your lordships through the agreement, and I've taken you to the relevant terms, and I've given you my submission that Article 1 delineates the roles between the parties, and that Article 6 provides for a license, and that it's exclusive. And as I've explained, that is in accordance with what was envisaged would be happening.
Yes, but the reason for the intervention is that if you're right on construction, it follows the judge was wrong.
Indeed, my lord.
And therefore, in a sense, what is more important is the arguments that are put against you on the interpretation.
I'm going to try and pick those up as we go through, my lord. My note does deal with what my learned friend says.
Is your essential point that Article 1 describes the activities which are the sole responsibility of KID?
Yes.
And therefore, it necessarily follows that Lufthansa can't undertake them.
Yeah, that's part of it.
That's what it comes to.
That's what it comes to. If there's any magic in the word responsibility, then of course the immediate next sentence talks about it as being the activities of KID. So it's not just responsibility, it is what KID is going to do. Also, that fits with what was envisaged at the time. We've seen that the parties imagined that the supply was going to be done by KID, the installation.
And I think it also is part of your argument that whether for the purposes of the domestic law this is an exclusive license or not, because we don't have an intermediate one, is simply a question of interpretation of this agreement, because there is no disembodied license, as it were, outside the terms of the agreement.
I'm not sure I followed your lordship's point, but certainly we're construing a contract to find out where that leaves the responsibilities and whether things are exclusive or not. We then have to apply English law to the outcome of that process.
Yes, but that's a subsequent stage.
But that is a
as my
subsequent.
lord is pointing out, because stage 1, interpret the document applying German law. Stage 2, once we've interpreted the document, is the result an exclusive license of a UK patent applying UK patent?
I absolutely agree with that, my lord. So, my submission is that I already showed your lordships the agreed principle of German law about the aspect of the process of construction being that an interpretation is to be sought which takes appropriate account of the legitimate interests of both parties and meets the requirements of fair commercial practice. And my submission is that an interpretation in which Lufthansa retained the ability or right to compete with KID by selling and supplying components would be contrary to KID's legitimate interests and to fair commercial practice and to the wording of Article 1. But we saw also that the principle of the good faith principle seeks to ensure that the spirit of the agreement is upheld. And the spirit of the agreement is, in my submission, that only KID is going to be supplying components. I'm going to make a submission that I don't think will invoke my Lord Justice Arnold's wrath, but if you take my skeleton, please, in the core bundle, I've set out Lufthansa's expert's explanation. So this is tab 14, page 262. And it's paragraph 37. And what I want to extract from this is not how the learned professor for giving evidence for Lufthansa applies the principle to the facts of the case, but what we can derive about how the principle of good faith works. The clause that says Lufthansa ought not be able to use the invention itself or in arrangement with a third party in a manner that would be contrary to the principle of good faith demonstrates in my submission that the principle of construction operates so that a party is not able to act contrary to that principle. As we saw before, the principle seeks to ensure that the spirit of the agreement is upheld. In other words, the application or construing an agreement in accordance with the principle of good faith requires that there is an obligation not to act in a manner that would be contrary to good faith. The judge, at no point in his process of construction, considered as an aspect of that process whether or not his interpretation took into account the legitimate interests of both parties of fair commercial practice. Had he done so, we contend that he would have realised that a construction in which Lufthansa is able to or has the right to supply and sell in competition with KID would be contrary to that principle. It would not ensure that the spirit of the agreement is upheld. And that emerges from the terms of the agreement itself, as my Lord Justice Lewison explains.
I mean, I think at bottom of your case is really quite simple, isn't it? Article 1 allocates certain activities as the sole responsibility of KID. It therefore follows that those activities are not activities which Lufthansa is free to carry out, otherwise they would be in breach of Article 1 of the agreement. Therefore, Lufthansa are excluded from those activities.
Yep.
And since KID has a license to do that which is described in Article 1, it follows that it is, in UK terms, an exclusive license.
Indeed, my Lord. And let's have a look at the way Lufthansa explains the position. So this is the core bundle, tab 15, paragraph 288. Sorry, page 288, paragraph 51. So this is Lufthansa's response. So the first point, where am I? It's 288, 50, little 1. Lufthansa says, first, the purpose of the agreement is a collaboration, and then it goes on, an interpretation in accordance with good faith assumes the parties will collaborate as they said they would. So far, that submission appears to accept that the principle of interpreting in accordance with good faith applies to create obligations on the parties. And then it goes on, and the agreement creates contractually binding obligations and benefits to that end. If one assumes, as D's must, that Article 1 reserves specific acts to KID, it follows that KID would have a route to enforcement under the law of contracts. So, as we understand it, the argument is that if you understand Article 1 as reserving specific acts to KID, then KID would have a contractual remedy. And Lufthansa says there would be no further need for a right to sue for infringement. But, and I think I'm about to say back to my Lord Justice Lewison what your Lordship said to me a moment ago, if once the agreement is interpreted in accordance with good faith, the upshot is that there are contractual obligations on Lufthansa not to carry out acts and a license for KID to carry out those acts, that is, when we then come to the second stage, a license that is exclusive within the meaning of the English Act, because there are obligations on Lufthansa not to act within.
There's a hidden premise in this submission, and I want to see if you accept the hidden premise. The hidden premise is that under the Patents Act 1977, a patentee who grants an exclusive license and the exclusive licensee then does something. The patentee then does something within the scope of the exclusive license. The exclusive licensee has a cause of action for patent infringement against the patentee, and not really a claim for contract.
And not merely a claim for contract.
At the moment, that seems to me to be a slightly broader proposition. As between patentee and exclusive licensee, the remedies are contractual ones, I would have thought.
It's still the remedy as against the patentee may be contractual, but the license is still an exclusive license.
To be sure. But the point about an exclusive license under UK law is that it puts the exclusive licensee in the same shoes as the patentee vis-à-vis third parties. It gives the exclusive licensee an independent right to sue.
And it does so by the contractual keeping out of the patentee.
Correct.
So that is why here, when there is a contractual...
But the point of the debate is this. What we are concerned with is the contractual relationship between the patentee and the licensee. We want to find out, is it exclusive? One of the consequences of saying it's exclusive is that puts the exclusive licensee in a different status vis-à-vis third parties. But the different status vis-à-vis third parties is a consequence of the license being exclusive as distinct from non-exclusive.
Indeed, my lord. And it's a consequence of the contractual effect of, in this case, a German contract.
But I mean, this process follows quite a familiar process, even in English law. First of all, we interpret the contract, in this case, according to the principles of German law. Having interpreted the contract, we then have to classify it. Does it fall into this category of contract
Under English
or
law.
that category of contract? I mean, is it a hire purchase agreement, or is it something else? Is it a lease, or is it a license? Is it an exclusive license or not? And that's the application of English law to the results of the interpretative exercise.
I agree, my lord.
And that classification will then have legal consequences, whether it's consumer protection or security of tenure or rights against third
It
parties.
gives a right to sue against third parties. Lufthansa's second point is at sub 2. I think it can be summarised this way. Your lordships could just read little 2. Because the licence was terminable, I'm summarising it, because the licence was terminable on 6 months' notice, KID was not in practice obtaining any material legal protection. There's no need to construe the 1998 teaming agreement as providing any obligations on Lufthansa not to compete with KID at all, because after the end of the 6-month period, KID wouldn't be able to manufacture. And the response is it simply doesn't follow that because after the end of a 6-month period,
you could have an exclusive license terminable on 6 months' notice.
And equally, my lord, it's agreed between us that this is at least a sole license for 6 months. That has some value. So if the idea of having 6 months is valuable in the context of a sole license, it's equally valuable in the context of an exclusive license. The last point is that in little 3, which I'll again attempt to summarise, it's saying that because the agreement is at least a sole license that prevented Lufthansa from licensing a third party to do that which, from licensing a third party to make components, that together with the fact that Lufthansa was not itself a manufacturer means that as a practical matter, Lufthansa was unable to supply in competition with KID. So from a practical standpoint, an interpretation that it's an exclusive license is unnecessary. The response is that, as I've shown you, it's not in dispute, as is evidence from the point at the top of the page of Lufthansa's skeleton, that the good faith principle seeks to ensure that the spirit of the agreement is upheld. It operates to require an interpretation that ensures Lufthansa doesn't compete. In other words, an interpretation is required that creates an obligation on Lufthansa to that end, and that's what little 1 at the top of the page, paragraph 50, little 1, appears to accept. So a construction that leaves it open to Lufthansa to be able to use the invention within the scope of the license would not comply with the requirement to interpret in a way that meets the requirements of fair commercial practice. The second point is that I don't think it was actually made out on the facts that Lufthansa could not sell or supply in competition with KID as a practical matter, because a sole license under the patent wouldn't prevent Lufthansa from obtaining components from a jurisdiction with no patent protection to sell and supply in competition with KID. So none of these 3 arguments undermine the key submission that this is an exclusive license. The last point I need to pick up is at paragraph 51. There's a contention that, what it says is this submission boils down to a submission that the judge, when applying the principle of good faith, should have placed greater weight on certain facts than others. Well, your lordships have heard what I've said about the threshold on appeal. Further, the point is that the judge was required to seek an interpretation which takes appropriate account of the legitimate interests of both parties. It's part of the process, and he didn't step back and ask himself that question at all, ever. And maybe it's because he didn't go through the agreement, but it's not an issue of having weighed up evidence on the points, he just didn't consider it. Okay, my lord, could you, your lordships, please take the judgment, page 379. This is the judge's reasoning. There's one point I need to address in relation to the way the judge reasoned. It relates to paragraphs 6 to 11, which I'm going to attempt to deal with all in one go. Subparagraphs 6 to 9 all essentially go to the point that Lufthansa was envisaged to be installing components made and supplied by kids. So, for example, we have at sub 9, the parties must have had it in mind that Lufthansa would be carrying out retrofit installations of the Sky Power system for which it would be required to exercise its rights as patentee. And then there's some reasoning that comes in little 10. The judge says if Lufthansa had granted KID a true exclusive license, then Lufthansa would not have been able to provide the services in Article 3, that's installation, without KID granting a sub-license. The second sentence continues, the 1998 teaming agreement did not contain a sub-license to that effect. So the judge's reasoning so far is that the license can't be exclusive, because if it were exclusive, then in order for Lufthansa to be able to install, there would need to be an express back license in respect of the act of installation, and there's not.
Exhaustion of rights.
Indeed, my lord. What about exhaustion of rights? What about sub-licenses implied?
Well, aren't you on slightly tricky ground in looking at the implication of terms? I think Professor Metzger said there was some principle called supplementary interpretation. He said it didn't apply in this case. Now, there is a danger of sliding into English law principles of contractual interpretation once we get onto implication.
Well, so I will have to show you then the evidence such as there was about exhaustion or implied sub-licenses, and I'll come to that.
Well, exhaustion of rights may not be a particularly English concept.
No.
But implied terms probably is.
Exhaustion of rights comes from German law originally, but has become part of English law via EU law.
Indeed, my lord. So I think I'm on a fairly...
That's me. I don't know whether there's any evidence to that effect is another matter.
My lord, let me please just carry on with this paragraph and make my submissions, and I will try and pick up these evidence points on the way. So, judge so far, the teaming agreement doesn't contain any sub-license to that effect, and then he carries on over the page and he makes an evidence-based point. Prof. Anne had no real answer to this when Mr. Hall put it to him in the passage immediately above, and I'll come back to that piece of evidence and the other reference to the evidence at the end of that paragraph. Prof. Anne accepted the sole exclusive license would give effect to the purposes of the agreement. There's a second bit of judicial reasoning in the intervening sentence where it says, in any event, there's no reason why the parties would have entered into such a complex arrangement when a sole exclusive license would have given both parties the rights which they needed. So the first error of reasoning in this section is in the proposition that if the license granted to KID in respect of the acts we're concerned with in this case were exclusive, then it follows that there would need to be an express back license. And our submission has been that if the license to KID covered installation in the first place, then the mechanism for Lufthansa to have the right to install is via an implied sub-license. And in my skeleton, I posed the forensic question of how it is that installers other than Lufthansa who receive components from KID have the right to install them without infringing the patent. If one stops the analysis at the point of concluding that there's an at least sole license to KID which covers the act of installation, the third-party installers would be infringing. So the argument is that those installers must be getting an implied license from KID, having been supplied components.
But this is why I raised the question of exhaustion of rights. I mean, this all goes back to the problem with Betts and Wilmot. Betts and Wilmot is the origin of the English law concept of an implied license of a patent. And the problem with it has always been that you can exclude it by express agreement. Hence the German scholar, I forget the name, who came up with the doctrine of exhaustion of rights, had a better answer, because exhaustion of rights, you don't need any implication. It is a principle of law, and it cannot therefore be excluded by express agreement.
My lord, I think for the purposes of my logic, it doesn't matter whether the third parties are entitled to install by virtue of an implied sublicense or by virtue of exhaustion having been supplied, having bought the goods off KID. Either route operates to give them the freedom to install. And the point is that if the third parties have that freedom as a consequence of having obtained the products from KID, then the same could be true of Lufthansa.
Is an implied license a permissible concept in German law?
Well, what the evidence was is that with the sale comes the agreement that you can do things with it.
That the experts gave that evidence.
Let me show you that evidence. So this is in the kids supplemental bundle, tab 15, page 142. Is the 68 of
Whose
the
evidence,
transcript.
whose evidence we're looking at here?
This is Professor Anne
Yeah.
being cross-examined by my learned friend. So at line 5 to 16 is what I've said.
Which manuscript page?
68.
68.
So if you pick it up, what's happened at line 5, what's happening in the parallel contract signed on the same day, and what's happening in the agreement is that Lufthansa itself may be purchasing these components. Those circumstances, Lufthansa will need to promote to the market, to the airlines, yes. So question's been put here not about installation, but about promotion. But the answer is, and if KID sells systems to Lufthansa, then with that sale comes the agreement that Lufthansa may perform things that otherwise KID would do. And if you turn forwards, my lord, to 148 of the bundle, to transcript page 89, at line 17, the question that I've just read out is put back to the expert. If KID sells, the answer, if KID sells systems to Lufthansa, then with that sale comes the agreement that Lufthansa may perform things that otherwise KID would do. Do you remember? Yes, I remember. Can you explain what you meant? I mean, the first question, this is an interesting one, is whether exhaustion has taken place. I mean, normally you would say, yeah, sort of yes, patented devices sold. Whether that holds true, if they're being sold to the right holder, unusual situation, I need to think about that. But what I meant was that when Lufthansa bought from KID, KID must have agreed, because otherwise the sale wouldn't have made sense. Must have agreed to Lufthansa doing things with these devices. And what things must it have agreed to Lufthansa doing with devices? Well, something meaningful. In other words, installing them. Basically what's said in Article 3, installing them, providing documentation, taking care of certification, things like that. So, my lords, there was the evidence.
About Professor Metzger.
There was no evidence from Professor Metzger. I didn't put the exhaustion or implied license points to Professor Metzger. But, my lord, what I did put to Professor Metzger was a point about the scope of the license, and that licenses may be limited by reference to different acts. And this brings me on to Lufthansa's response to this implied license or exhaustion point. What Lufthansa says is that when in Article 3, it's contemplated that a buyer chooses a third-party installer, Lufthansa says Article 3 operates as a license direct from Lufthansa to that third-party installer. So a license from Lufthansa in respect of installation. And of course, given that this is a sole license...
Sorry, that seems like quite a strange argument. Can you remind me where we find the article?
This is in Lufthansa Skeleton, in the article, sorry, it's in the confidential bundle. Tab 2 of the confidential bundle is the teaming agreement.
This is Article 3, is
This is Article 3, the one about system installation. So the one that envisages that third parties will install if they don't choose.
Sorry, can you help me? Maybe being very slow. This is a contract between KID and Lufthansa.
Indeed.
It's not a contract between Lufthansa and third-party installers.
Well, my lord, I think all I can do is show you the way my learned friend put it.
Leads to this question. It may be the case, I mean, we've had a lot of cases recently about this concept in French law and Swiss law, so maybe it exists in German law, I don't know. Contracts for the benefit of third parties. So was there evidence put forward by Lufthansa about contracts for the benefit of third parties under German law?
No. Lufthansa's submission, it is a submission, is that this article operates to grant a license to third parties. I'll just tell you what the submission is, my lord. To allow them to install. Now, the point I wish to make in response to that is that because this is a sole license, you can't have a license both to KID in respect of installation and the third parties. So it is implicit in my learned friend's argument that actually the scope of the license to KID does not include installation. That's implicit in his argument. What's happening instead, he says, is you've got a license to KID in respect of the things that KID is doing in Article 1, those acts. The right to install is not part of that license, and instead that therefore leaves it open to Lufthansa to grant a license to third parties. And the point I was going to make is simply that that doesn't help him, because the judge's reasoning here is that there can't be an exclusive license, because if there was an exclusive license, then Lufthansa needs to be able to install. But this scope of the license point envisages that Lufthansa has the right to install because it never licensed it to KID at all. So whether one considers that third parties and Lufthansa are sub-licensed in the way that Professor Anne explained, or Lufthansa's response that they're directly licensed by Lufthansa without the license to KID covering installation. The license to KID is limited to the acts in Article 1. It's envisaged that at all times that Lufthansa installs. Therefore, the license granted in Article 6 never covered installation. That still negatives the judge's analysis that this can't be an exclusive license because Lufthansa needed the right to install.
Well, I mean, the fallacy that you are suggesting is that it doesn't follow from the fact that an exclusive license, that a license is granted for activities 1, 2, 3, and 4, but not for 5, means that the license for activities 1, 2, 3, and 4 can't be an exclusive license.
Indeed.
It just means that they are exclusive, but within that scope.
That's the scope of the license. Yeah. And indeed,
Installation is not mentioned expressly in Article 1.
It's not. And in Article 3, it's envisaged that it's certainly not envisaged anywhere in this agreement that the installation is going to be done by KID.
No, it's going to be either Lufthansa or another.
Exactly, my lord. And I'm sorry, I spoke over your lordship, but pretty much the first question that I asked Professor Metzger was that it is possible under German law to partition a license by reference to different acts.
Is that a question of German law, or is that a question of English law having interpreted the contract?
Well, I think it's a question of German law in respect of whether or not you can construe a German agreement as giving a license in respect of one act or another. So, my lords, I said I would come back to the evidence references in paragraph 10. Could you please take in the judge's judgment? I think the evidence that the judge is referring to here is the long passage in 684, so that is page
376.
I'm grateful, my lord. And just to remind you, what the judge interprets this as is he in little 10 of 68510, he says Professor Anne had no real answer to this point when Mr. Hall put it to him, and the point was the judicial reasoning about if KID had granted, sorry, if Lufthansa had granted KID a true exclusive license, then Lufthansa would not have been able to provide services without KID granting a sub-license back. And I think the critical bit of the evidence is 12 lines up from the bottom of the page. So there's a question on if they are involved, each involved in the end-to-end process, and aspects of that end-to-end process are covered by the patent.
Where are we?
Sorry, my lord. 377.
Yeah.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10 or so up from the bottom.
Various got it if they're involved.
If they're involved, each involved in the end-to-end process, and aspects of that end-to-end process are covered by the patent, then both Lufthansa and KID need to have rights in the patent for that purpose, yes. And so under German law, a sole license to KID under which Lufthansa retained its own rights would achieve the purpose of this agreement. Could you say that again? Under German law, a sole license to KID under which Lufthansa retained its own rights would achieve that. Sole license to KID would achieve the purpose of this agreement. Yes, a sole license would achieve that purpose. Well, it doesn't mean that that's the only way, but it's yes.
Is any of that evidence admissible? Because it's all about German patent law, which is irrelevant.
I agree, my lord. It's also not evidence in support of what the judge said it was, because it's not evidence. The judge said Prof. Anne had no real answer to this point, as if there had been some questions about whether or not Lufthansa would have been able to supply the services in Article 3 without KID granting a sub-license. There's nothing here about sub-licenses. We put a question about a sole license achieving a purpose, that purpose first of all, and then the purpose of the agreement. So I'm afraid that the judge's statement that Prof. Anne had no answer when it was put to him is, well, probably inadmissible, but incorrect in any event. And then at the end of the paragraph, he says, Prof. Anne accepted that a sole exclusive license would give effect to the purpose of the agreement. And here, my notes, I think, picks up on what Lord Justice Arnold has just said. The question of construction is ultimately one for the court and not for the experts in German law. This is obviously not evidence of German law, but rather evidence about the effect of the construction of the contract, if it's admissible at all, which I think we're getting to the position that it's not. When the judge at the end of 68510 refers to the purpose of the agreement, he means, well, it's not very clear what he means. Does he mean a purpose as described in the previous sentence, so giving Lufthansa and KID the rights they need to carry out their respective activities? Or is he saying the purpose of the agreement in a more general sense? If he's saying that it was evidence that a sole license will give the parties the rights they need, well, that's also true for an exclusive license. In order for them to carry out their respective activities, it's also true for an exclusive license. So it's not a reason for negativing the idea of a sole license. And if it's accepting some answer at a more general level, that a sole license would achieve all the requirements of this contract, then I would say that that's a conclusion that the evidence simply doesn't bear. It's probably inadmissible anyway. So in my submission, the reasoning in 6 to 10 of this, subparagraph 6 to 10, there's a lot of judicial reasoning in there, and in my submission it's wrong.
When the judge says at the end of 10, Professor accepted that a sole exclusive license would give effect to the purpose of the agreement, he's just referring to the evidence which is recited at the bottom of page 47, where the question was, a sole license would achieve the purpose of this agreement.
Yes.
And at the beginning of that passage, 1376, identifies what the questioner and the witness have agreed, what the purpose is to agree on a collaboration. So, I mean, he's just picking up this evidence.
He is, but I don't think it supports the point he's making.
The point the judge is making is that a sole license would do what was needed, so why agree anything more complex? That's a slightly different point.
It is a different point.
But the evidence that's relied on is German patent.
Well, yes, entirely.
Whether this would be a sole or exclusive license of a German patent is not a question that we have to decide.
Indeed.
Which is just as well, given the German courts have dubbed it twice.
My lords, I was going to move on to paragraphs 6, 8, 5, 2 and 3 of this. So the key points of this paragraph, these two paragraphs, are that where the judge says it was not intended, he's talking about Article 6, it was not intended to confer unlimited intellectual property rights upon KID, which it could exploit for purposes outside the agreement. And then at the end of that paragraph, the clause, if KID had been permitted to exploit intellectual properties for other purposes, then in sub 3, there's the reference to outside the collaboration. And the purpose has been given in little 1 as being the collaboration. We saw that the collaboration imposes specific requirements upon KID, such as to recommend Lufthansa's installation services and to pay royalties. So the judge's reasoning, as we understand it, must involve the premise that an exclusive license would require KID to work its license for non-collaborative purposes. It would be working its license, the judge's reasoning, in a way that doesn't involve complying with its collaboration requirements, such as to recommend Lufthansa's installation services. That's obviously wrong, my lord. An exclusive license does not require KID to work its license for purposes outside the agreement, or in a way that does not comply with the requirements imposed upon it under this collaboration. If KID had an exclusive license, it's still collaborating with Lufthansa, it's still working within the agreement, still complying with the collaborative purpose, if it still carries out its requirements to recommend Lufthansa and to pay its license fees. It's working within the collaboration, even if it has an exclusive license. So I'm afraid the judge's reasoning just doesn't stack up. The exclusivity of the license doesn't cut against kids' requirements to pay royalties or to recommend Lufthansa for installation. Now, Lufthansa says that we've got this reasoning if the judge is completely wrong, and that he's not making a point in support of his conclusion at 685 about whether it's sold or exclusive, and instead he's making a finding about the scope of the license. I need to do this off the documents because it's complicated conceptually. Could you turn, please, to paragraph 53 of my learned friend's skeleton, so the core bundle, tab 15, page 290. Paragraph 53. Picking it up in the middle, D's have misunderstood the argument which the judge was addressing, namely, whether any license to KID was limited to the advanced system, the system which KID actually manufactured, or was broader, covering the mPOWER systems devices manufactured by Astronics. So here, advanced system is not being used to refer to the technical concept covered by the patent, but as a shorthand to refer to the embodiment of that concept when made by KID. Lufthansa is saying that in these paragraphs, the judge is making a finding not about whether it's sold or exclusive, but about the scope of the license. They're suggesting that the judge found that the scope of the license covered KID's Act, but only when KID was cooperating. So in effect, the license only covered products made by KID and does not extend to Astronics doing the same acts. So just pause to consider that. It's being said that this is a sole license to KID, so it excludes third parties, but the scope of the license is limited to KID supplying when KID fulfills its cooperation obligations. So Lufthansa could license somebody else to do exactly the same thing because they're not doing it whilst cooperating with Lufthansa, and therefore they're outside the scope of KID's license. I hope, my lords, that having just said that, that sounds wrong, because my submission that is wrong. A license with a requirement to pay royalties is not a license limited to when you pay royalties, so that you can license somebody else in exactly the same way to do exactly the same things because, the scope of the license that I gave the first licensee was limited to when they pay royalties.
That's also not how I understood this particular point when reading the skeleton, but I may well have misunderstood it. I thought that what was being said in this paragraph was that the license to KID was limited to the system which KID actually manufactured and was not broad enough to capture anybody else's system, even if that other system
That is the same
embodied
point,
the inventive concept.
that is the same point, my lord. The license is limited to exactly what KID does when KID does it.
Yes.
If somebody else uses the advanced system concept and the mPOWER system, what Astronics did, that's outside the scope of the license. That's the argument.
In which case, why is it a sole license?
In which case, why is it even a sole license? Doesn't stack up.
Is this a question of construing words exclusive users right in Article 6? An exclusive users right?
Sorry, is this argument, or I mean, obviously,
This argument about what it is a license to do.
I don't think it can flow from that. I think it can flow only from, I mean, maybe a construction of advanced system.
It's a combination, isn't it, of construction of advanced system
And
what
cooperation.
and what is the sole responsibility of KID under Article 1.
and I think the cooperation obligations. So I think the argument goes that the KID is only licensed to do things when cooperating. So KID is only licensed to make what it makes when cooperating, to make its own product. And the mPower systems made by Astronics, even though they fall within the scope of the license, fall within the scope of the patent, they don't fall within the scope of KID's license.
That's a complete non-argument. Any licensee is always licensed to do what it itself does. And it has no bearing on the distinction between sole or exclusive, which is only as between the licensee and the patentee.
Well, I'm glad your lordship says that. I think that might mean I can take a moment just to review my note and see whether I can strike through some of the potential answers to this argument. I'll do this in very short form then. I'll give you the bullet points. The first was, if the judge is making a point about scope of license, then it doesn't support his conclusion on the nature of the license, because scope and nature are orthogonal considerations. That's the first point. Secondly, I, like my Lord Justice Arnold, don't agree that this is what the judge is doing. I'm not sure that's what my Lord Justice Arnold said, but I don't think this can be what the judge is doing because it's so demonstrably wrong. Also, it's not an argument actually that Lufthansa put in its closing. It makes a point in its closing below, and it makes it on appeal about the collaboration and the need for collaboration, and it makes a point that somehow that impacts whether it's going to, whether the license is sole or exclusive. But this is a different point. This is about the scope of the license, and Lufthansa didn't make this scope of license point in its closing below. It did not contend that the scope of the license was limited such that Astronics and Panasonic's activities would fall outside the scope of the license. I pointed out in my closings below that they hadn't made that point and said it had been abandoned. And they said in response that it hadn't been abandoned. It was still, they said in response it was still a good point, but it was unnecessary. So they positively disavowed reliance upon it. You have my points about it not being a good point. The judge made no findings of German law to support such an argument. It's plainly wrong. And furthermore, the judge explicitly and correctly found that the scope of the license did cover what Astronics and Panasonic did with the mPower system. If you turn forward to 6859, that's wrong. It's 6879. He's talking here about one of the German decisions and picking it up halfway through the paragraph. The defendants relied on a particular paragraph of the German appeal court decision for the proposition that Astronics' infringing acts fell within the scope of the license. And the judge says, but that was the point. The acts infringed the rights which Lufthansa had granted KID for the purpose of their collaboration. So there's an explicit finding that the scope of the license extended to cover exactly what Astronics and Panasonic had done. The next point is the judge's finding in 6854. I'm sorry, my lord, I was just checking on timing. 6854. Last sentence, Professor Anne accepted that it was unnecessary for Lufthansa to grant KID a true exclusive license to perform this obligation, but only a sole license. This is, I think, referring to the same bit of evidence we've just seen, and the point is very short. If all one looks at what's necessary for KID to carry out its obligations, the answer is a license of any kind. A bare license would be sufficient. So this is not a paragraph in support of the judge's conclusion. Lufthansa's answer is to say, well, there are other bits of the judgment where Prof. Anne accepted that a sole license would achieve the purpose of the agreement. Those are the other passages. I think that's really referring to 68510, and we've been through that already.
But this is a false dichotomy, isn't it?
I'm sorry.
This is a false dichotomy.
It is, my lord.
No, I think your submission is a false dichotomy. Of course, a bare license would be enough, but the agreement uses the word sole, or exclusive user's license, or whatever the phrase is. And the German law experts, in effect, said you can translate that into one of two German concepts. The question for the judge was which one, but bare license wasn't on the menu. So how does your point that a bare license?
The point is, my lord, that the judge is relying on this to say that it's an exclusive license.
Yes, but what he's saying is, as between the two options that I've got, the lesser of the two will do the job. He's not saying more than that, is he?
Well, he may not be saying more than that, and the point is, well, a lesser license would do the job, an even lesser license would do the job, a bigger license would do the job. You can't rely on the fact that you need a license to carry out these obligations as a reason for why it must be a sole license.
And you can rely on it saying you don't need what he calls a true exclusive license.
You don't need a true exclusive license
That's
to
all
carry out your obligations.
That's all he's saying.
If that's the limit of the point, in my submission, that doesn't support the idea that it has to be.
It doesn't get you to the answer, but it's part of the strand of the reasoning that you can do what you need to do with a sole license rather than a true exclusive license. I don't read anything more sophisticated into it than that.
I'll back away then, because I think we immediately then start moving on to the further considerations I've already given you about, well, what do you need in order to comply with good faith and to ensure that the expectations of KID are protected and all the rest of it. And then, of course, the submission is you do need more than a sole license for that. In little 5, the judge relies on the use of the word sole in the context of Article 1. So this is in the context of Article 1 saying that it's KID's sole responsibility to carry out the activities that are listed there. And he says it's fair to say that the word is used in the context of KID's obligations under the agreement, not its rights. But the parties could have easily have used the word exclusive in that context. The word sole provides some insight, therefore, into their intentions. I need to show you the evidence about the use of the word sole and exclusive, and that's at 655 of the judgment. The judge records that there was some evidence about the German term Allein license, referring to the license which excludes third parties but not the patentee, and that term translates into English as a sole license. He's recognised in 6.
Can you explain to me what's the relevance about it? It's because this was an English language agreement, so it didn't use either of these German language terms. Now, was there evidence that the English language agreement that was signed was a translation of some German language draft?
None of that, my lord.
So, what is the relevance of evidence as to the meaning of German language expressions which are not used in this document?
Well, my lord, he says it's fair to say that the words used in the context of kids' obligations under the agreement, not its rights. And in my submission, he should have stopped there because there was no evidence that German speakers contracting in English would contrast the use of the word soul in the context of...
And this must all be in the context of German patent law. We're not in the field of German patent law, this is UK patent law.
Well, Lufthansa says the judge attached limited weight to this point, and in my submission, he was wrong to attach.
But it's not always true that the word soul in Article 1 is doing any more than say, as between KID and
Lufthansa, yeah.
KID's going to be responsible for doing these things, and Lufthansa is going to be responsible for doing other things.
Yeah, soul in that context is delineating the responsibilities of the two parties who are being addressed. In fact, I think at least one of the German judgments interpreted Article 1 as saying that the market introduction of the advanced system shall be the exclusive responsibility of KID. So such evidence as there was about how a German court would understand, or understand English, German speakers contracting in English, was actually that they would understand soul to mean exclusive in the context of delineation of responsibilities. The judge is trying to extract some further meaning about licensing, which I'm afraid it just doesn't bear.
Soul means me, not both of us. Soul means me, not both of us.
The next issue is the judge's reliance on the German decisions. So this is 686 of his judgment. He said, in my judgment, his decision is consistent with, and he lists Mannheim 1, Appeal 1, and Mannheim 2. In particular, it's consistent with the findings of the Oberlandesgericht in Appeal 1 in relation to the purpose of the agreement, and in particular, the court's findings that it did not confer a right upon KID to grant sublicenses to third parties for other systems without Lufthansa's consent, because such a license would have been beyond the rights that KID received under the agreement. The submission is that if the judge drew support from the German decisions for his conclusion about whether it's sole or license, he was sole or exclusive, he was wrong to do so because the German decisions expressly do not determine that issue and provide no support for that conclusion.
Applying German patent law.
I beg your pardon?
Again, they're applying German patent law.
Lufthansa says the judge doesn't rely on these on Appeal 1 in support of his decision. He says all he does is identify that it's consistent with it. And explicitly it says he doesn't rely on those findings as being consistent with his decision on sole or exclusive. So probably that's all we need to say about Appeal 1. Lufthansa doesn't contend that it supports the judge's decision. I think what I'm going to do, given the time, is move on lastly to the last error in relation to the transfer purpose paragraph, which is in 688. So what the judge does in this paragraph is he says, even if I'm wrong about the construction of the 1998 teaming agreement, and on their true construction, the words exclusive users right does not mean a sole exclusive users right, either because my reasoning is wrong or because I've relied upon inadmissible or unpleaded material, I would have held that these words were ambiguous and applied the transfer purpose rule. So let's just pause there. The first mistake is in the assumption that the transfer purpose rule can be invoked simply if words are ambiguous. And the second mistake, it's not a correct application of the transfer purpose rule to apply it as a fallback in the way the judge has done. So the judge's findings on the transfer purpose rule are at 659. And he identifies that it's a rule of last resort And towards the end of the introduction of that paragraph, he accepts the evidence that it applies if all the principles of interpretation have been exhausted and there remains a doubt whether a true exclusive license or a sole exclusive license, or indeed a non-exclusive license, is intended by the parties. Then it should be construed as only conferring rights which were necessary to give effect to its purpose. And the bit of evidence is set out there, and the key bits is over the page. In fact, I'll just read it out whilst you find it. Question, and so the same principle applies when there's a doubt about whether an exclusive license is a true exclusive license or a sole exclusive license. The answer comes, if, well, doubt means, well, then we have to talk about what constitutes sort of doubt in that sense.
Understand this evidence. Is this evidence about German contract law or German patent law, or possibly intellectual property law? Because I know there's a reference to.
I think this is contract law.
This is contract. Okay.
Yeah. If well doubt means, then we have to talk about what constitutes. I paused as the thought hits me. This is, I think, contract law, but it was given in the context of copyright contracts and patent licensing contracts. So he says doubt here just means that. It doesn't mean that, well, when sort of looking at a license agreement, one says, oh yeah, you can like read it this way or that. Doubt means that if all principles of interpretation determining the party's intent have been exhausted, there's still unresolved doubt. So it's very clear that the rule doesn't apply simply to ambiguous wording. It only applies if all the principles of interpretation, including the principle of good faith, have been exhausted. And so the judge was wrong to suggest that ambiguous wording was a basis for falling back upon it. And the way the judge then relies on it, just to say, oh, well, it's a fallback if I made an error of reasoning or relied upon something I should, not. The submission is that if the judge's reasoning is wrong, so his primary conclusion can't be supported, then the question becomes, well, what is the correct construction applying the agreed principles of German law, including the principle of good faith, principle of seeking to ensure that the spirit of the agreement is upheld? Does one end up at a construction? Or, once one's been through it, is there still unresolved doubt? But you can't short-circuit that and simply say, well, if I'm wrong, then unresolved doubt, I'm going to apply the transfer purpose. If the judge has made an error, then we have to assess whether actually there is an answer once the process of construction has been performed correctly. So 688 involves an incorrect reliance on the rule. And then he goes on at the end of 688, a sentence that's not very clear, but in my submission it's to be understood. He says, I would have also followed the German decisions and held that the 1998 teaming agreement gave rise to sole exclusive license. Of course, the German decisions didn't hold that, so I don't think he can be saying I would have followed them in their findings, because he's explicitly accepted that they don't determine that question. I think what he means is he would have followed the German decisions in holding that the purpose of the agreement is a collaboration, and then he would have relied again on Professor Ann's evidence that it was only necessary for Lufthansa to grant a sole exclusive license to give effect to the purpose of the agreement. But if the judge has made an error of reasoning, relied on evidence he shouldn't, it doesn't follow that you apply the transfer purpose rule and so conclude that a sole license is sufficient to give effect to the purpose. In my submission, it's not necessarily the case that carrying out the exercise of construction without making the mistakes the judge made leads to a conclusion that there's still doubt. Indeed, my submission is that if you carry it out correctly, there is no doubt. It's an exclusive license. So falling back on Professor Ann's evidence and purpose and transfer purpose is wrong. Plus, of course, there are the points we've already been through about what Professor Ann's evidence about the purpose was actually about and whether it's admissible at all. And lastly, I need to just address Lufthansa's contention that the two courts in Germany twice declined to decide whether the license was exclusive or not, because, and what my learned friend says is they considered it sufficiently nuanced that they twice declined to decide it. So I think Lufthansa's contention must be that because the German courts did not feel it was necessary to decide the exclusive license point, that issue falls into the category of being one to which the transfer purpose rule applies. That is obviously confusing the law of when to apply the transfer purpose rule, that it's a last resort, with the different issue of whether it was necessary for those German courts to decide that issue. A decision might be unnecessary, it might be time-consuming, it might be difficult, without being one that falls within the transfer purpose rule. So although it sounds nice to say, oh, well, the German courts didn't decide the issue, so transfer purpose rule applies, that is not how German law works. I think, given the time, the last point is the consequences of allowing the appeal. If the appeal is allowed, and Lufthansa's respondent's notice on the correct construction of Section 67 of the Patent Act is rejected, then the issue becomes what to do. One analysis is that 100% of the profits, which the judge has found were attributable to the defendant's acts in respect of supply, should be attributable to Kidd's compromise share, because they were all derived from infringement of Kidd's slice of monopoly from supply in the relevant period, crucially, in the relevant period. So it wouldn't be the whole of the 13%, it would be that portion that applies in the relevant period. That portion for which the teaming agreement overlaps with the relevant period.
Do we know what the basis of the settlement was? Do we know what the basis of the settlement was? I personally don't know, but if, for instance, the settlement was with Kidd was based on Kidd's loss, but the claim now is not for Lufthansa's loss, but your profits, how would those two fit together?
The settlement agreement between Kidd and General Dynamics, that's what you're referring to?
Yes.
That was a settlement agreement in which there was a cross-license, including in respect of the General Dynamics, the GDAES power management patents. And it is in the bundles, and we did plead a point that that represented a cost to General Dynamics and Astronics, a cost of carrying out its acts. But the accountancy experts were unable to quantify that cost. So I think the answer to my Lord's question is that it was a complex agreement and it couldn't be quantified. So one could say, well, all of the profits that flow from the acts of infringement should be attributable to Kidd's slice of the monopoly, because they were in respect of Kidd's licensed activities. And that is perhaps the most satisfactory response. But in the absence of that approach, the proposition that we put forward is that Kidd's profits, the proportions in which Kidd's profits from the use of the invention were split, the proportion in which they were split between Lufthansa and Kidd in the teaming agreement could be used as the basis for the division between Lufthansa and Kidd. Lufthansa never disputed that approach, And although at trial we sought disclosure to try and work out that disclosure wasn't forthcoming, and as you were shown this morning, I think possibly yesterday, Lufthansa did not put up a witness testifying to those numbers. So we have to fall back on Mr. Bazant's evidence of a range. Mr. Bazant gave the 25 to 50% over the. He also explained what factors might apply to say where in the range a figure would lie. And he gives the opinion that the figure may be towards the lower end of the range. But in seeking to try and use that methodology, we are assuming against ourselves, notwithstanding Mr. Bazant's evidence, and putting forward the 50%, the upper end of the range. Even though obviously the more satisfactory, intellectually satisfactory result is to say, well, actually, all of these profits were attributable, fell within Kidd's slice of monopoly. Lufthansa's respondent's notice is to say, well, Mr. Ryan put in some evidence about 84%. You've already heard from my learned friend, Mr. Purvis, that they described that evidence as, well, they said he fairly acknowledged in writing and orally that he wasn't putting it forward as a particularly informative approach. And we've had endless discussion already about what was done with that evidence. So we're left only with the 25 to 50% as being the only figure that was put forward. So unless I can get prompted by anybody else, or
No, thank you very much.
question, that's all I have.
Who's dealing with this? Mr. Hall?
Yes, fine. Can we please pick up judgment at paragraph 600,
Paragraph?
paragraph 653. On page 357. This is where the judge sets out the issue that was before him. He says that the teaming agreement was governed by German law. He refers to the expert evidence. And then at paragraph 654, he says, I've set out the terms of the 1998 teaming agreement in section 2. And he says, the issue between the parties related to the true construction of Article 6, and in particular, the meaning of the term an exclusive user's right. That's the decision, the issue that was before the judge, that is the issue that he decided. If I could ask your lordships to also look at paragraph 29 of my learned friend's skeleton argument for this appeal. I'm afraid I don't have the reference in the core one. I think it's tab 14, but I don't have the number. 14, page 260. And what you see there is the case on this appeal, just as it was put before today. The Astronics and Panasonic's case is that the meaning of Article 6 is clear and unambiguous. That applying German law, the grant of the exclusive user's right comprised an exclusive license in respect of the acts of issue, namely supply. So the premise of the argument below, and the basis on which the evidence was led, the premise of the argument of this appeal as it was put, that was all about the meaning of those four words. There's been a shift in that regard in the discussion that has gone between my learned friends and
Is
their
that right?
lordships.
Because they start at paragraph 16 with the preamble, and paragraphs 18, 19, and 20 they place a lot of emphasis on Article 1.
I take my Lord's point, and it may be, my Lord may be entirely correct, but from this side we detect that there's been a shift. And so, given the time, what I'm minded to do, if your Lordships agree, is to take our respondent's notice point on the statutory interpretation first, and then come back tomorrow to respond to the way my own friend has advanced his
Can
opinion.
I just inquire about the timetable? We've got to finish all these appeals tomorrow. So how are we doing on that front? We seem to be overrunning on most of them now, so what are we going to do? Squeeze in the interest and double recovery appeals, or what?
I think we're still doing all right on the time. That was the position at lunchtime. I'm sure I'll be told by those behind me.
As long as we are.
It's different.
Right. You want your respondent's notice point?
So if I may, what I'll start with is our respondent's notice point, which is the statutory interpretation. It may be helpful to have the statute to hand. It is in the Joint Authorities bundle behind tab 1. And section 61 and 67 are at pages 21 and 23. It's also, as it happens, it's in our skeleton at 77 and 79. We've got two main sections. The premise of this argument is that under the 1977 Act, KID did have an exclusive licence covering the acts of infringement in question. So it had a right to bring proceedings under section 67, and it settled that right. And given that Astronics and Panasonic are beneficiaries of that settlement agreement, the question arises as to what bearing that has on the profits that Lufthansa may recover. Astronics' case below was that what KID had settled was the right to claim some relief from Lufthansa from Astronics in the form of a portion of profit, and that because it had settled that claim, it was necessary to quantify that portion. And our case, on the other hand, was based on the asymmetry between the patentee's rights under Section 61 and the Exclusive Licensees Act's rights under Section 67. We said that the mere existence of KID's claim had no bearing, under Section 67, had no bearing on Lufthansa's claim under Section 61. And so we said the fact that KID had settled that claim, which had no bearing on Lufthansa's claim, was irrelevant. And my learned friends, in their reply skeleton on this appeal, have changed their position a little. And we can pick that up in paragraph 22 of their reply skeleton, which is in the core bundle behind tab 17, page 310. And they describe here what they say now is the correct position. They advance two propositions. First, in A, they assume that the exclusive licensee has a right not just to a claim for relief, but has an inherent right to a share of the infringer's profits. And they say, in the fourth line, that exists irrespective of whether an action is brought by the exclusive licensee, and it's something that shouldn't be ignored when the court considers the profits award to the patentee on account. And second, in B, they say 5 lines up from the bottom, this is in a section 61 case brought by the patentee. They say the court should take into account equitable considerations, including if it be the case that there is an exclusive licensee with a cause of action for its share of the infringer's profits. So the dispute appears to have shifted a little now to, does KID have an inherent entitlement to a share of the infringer's profits? And that's the argument that I want to address first. We say that there is no basis for the assumption that KID had an entitlement to a share. We say that the exclusive licensee's entitlement to any financial remedy must depend upon the terms of its exclusive license. And it may be convenient to consider the situation where there is no exclusive licensee. Imagine there is a patentee with a patent, and it sues under Section 61, and it is therefore entitled to claim all the profits, as we've been discussing, legally and factually caused, derived from the infringement. If the next day an exclusive license is struck between the patentee and the exclusive licensee, the question is, what bearing has that exclusive license had on the right that was there the previous day? And the answer to that in our submission must lie in the terms of the license itself. One needs to go through the terms and look to see whether the patentee has given that entitlement away or any share of it. And of course, the license might provide that the patentee takes responsibility for the litigation and reaps the benefits, or it might say that the licensee has to do that and take the benefits, or it might allocate responsibility, it might divide the share. So whether the licensee is entitled to anything in litigation must be a matter, in my submission, for construction of the license. And it is wrong to assume that there must be such a share.
What if the license is silent?
I beg your pardon.
What if the license is silent?
If the license is silent, we say that's not enough. Or rather, I suspect the right answer to that, better answer, I apologise, is that one has to go through the license and seek to construe it. If there is no express express wording giving away those rights, there may be an implied term to that effect. That may be implied into the license. And here we are talking about a license under German law, so we would need to look at the German principles to that effect.
I don't quite follow.
That wasn't a point that was advanced.
If we interpret the license and we decide that as a matter of interpretation in accordance with German law, it does create an exclusive license. Section 67 tells us what, as a matter of English patent law, is the consequence of that interpretation.
Yes.
Now, you may or may not be right that you can exclude the statutory consequence,
Yes.
but contractually, in some statutory consequences you can exclude by contract and some you can't. But surely the answer to my Lord's question is, if it's silent, then the statute tells you what the consequence is.
Well, my submission, and we're going to look at the statute in a moment, is that the statute tells you that you should look to the license to see what the terms are. Because we can see that in the contrast between Section 61 and Section 67. So if we look at Section 61, 1D, which is the patentee's right, that is to an account of profits derived by him from the infringement. And we can contrast that makes no reference to any share. We can contrast the patentee's position with that of the exclusive licensee in Section 67, sub 2. Section 67, sub 2. The court or the controller shall take into consideration any loss suffered or likely to be suffered by the exclusive licensee, or, as the case may be, the profits derived from the infringement, so far as it constitutes an infringement of the rights of the exclusive licensee as such. And this is, of course, in proceedings brought by the exclusive licensee, that being what's happening in section 67, subsection 1. Now, if one considers the position in respect of loss, any loss suffered by the exclusive licensee will depend upon the terms by which the bargain is struck between the licensee and the patentee, because the licensee may be required to disgorge some of its sales, for example, to the licensee, to the licensor, and so the extent to which the exclusive licensee has made a loss will depend on the terms of the license. And we say the same is true of the profits. One has to look at the license to see whether the licensee has any entitlement to a share of those profits. The answer may be it does, the answer may be it doesn't. The statute doesn't give the licensee an entitlement to a share. That is derived from its license, if at all. And in this case, Astronics has never sought to construe the 1998 teaming agreement as entitling KID to a share of the profits. That isn't expressed in the agreement. They didn't advance a case of implied terms under German law, supplementary interpretation, as the Germans call it. And the transfer purpose rule under German law says that if there is ambiguity, then what is transferred is only that which is necessary to give effect to the purpose of the agreement. The purpose of the agreement is collaboration. And it wouldn't be necessary to that purpose to give KID a right to recover profits from an infringer. That's my submission. And so there is no basis for construing the license as giving KID an entitlement to a share. And we can see that differential treatment between the patentee and the licensee reflected elsewhere in the Act. Because the exclusive licensee's route, the only route to bringing a claim, is via Section 67. Section 67(1) says that right is subject to the provisions of that section. We just looked at Section 67(2). 67(3) also has a particular proviso. The patentee shall be made a party to the proceedings. So in any claim for profits brought by the exclusive licensee, the patentee is joined. And there is no equivalent provision in Section 61 by which the exclusive licensee is made a party to the patentee's claim for profits.
Are you differentiating for this purpose between profits and damages? Do you say that, for instance, an exclusive licensee is not entitled to damages for lost sales unless the terms of the license say he is?
It will depend upon the terms of the license. The license may say that under the terms of the agreement, the terms of the license, the exclusive licensee is not entitled to any of the spoils of the litigation. In the usual way, we see agreements assigning causes of action and the benefits that are reaped from those causes of action. It's an asset that can be assigned. And what matters is how that asset is treated in the agreement that creates it. Now I'm going to come on into why there is this differentiation.
I come back to the question I asked before, because I take your point that these matters may be regulated by contract between the parties, and if they are regulated by contract between the parties, then the court should give effect to the contract. That I see the force of that. But what happens in circumstances where the contract is signed, which is my Lord's question in the context of damages? What does the court do then?
In the context of an agreement governed by English law, my submission would be that one would have to look at the agreement and say, is it appropriate to imply a term into this agreement to that effect? Is it
But the
necessary?
premise of that submission appears to be that this is exclusively a matter for contract. Wonder about that, because one might say it's open to the parties to regulate by contract, but in default of contract, it's a matter for UK patent.
I guess if we go back to the submission that I began with and said, imagine the position before the license is struck. The patentee has an absolute right to the whole pot of profits. Can't be any dispute about that. Then the license
Sure,
is...
but once you grant an exclusive license, to that extent, you're putting the exclusive licensee in the shoes of the patentee. And it might be said thereafter, the primary entitlement to any profits would be that of the exclusive licensee, and that one might have thought would be what subsection 2 of section 67 is driving.
Well, that would, in my submission, be the case if section 61 stopped where it was. If section 61 says the holder of the exclusive license has the same right as the proprietor of the patent to bring proceedings in respect of any infringement of the patent committed after the date of the license. References to the proprietor of the patent and provisions of this act relating to infringement shall be construed accordingly. Now, pausing there, if that were the end of it, I would accept entirely that the exclusive licensee is entitled to an account of the profits derived by the infringer from the infringement, in the same way as the patentee is. But the problem is that section 67.1 is expressly subject to the provisions of this section. And what section 67.2 says, it doesn't say exclusive licensee is entitled to the profits derived by the derived from the infringement.
Well,
it says profits derived from the infringement so far as it constitutes an infringement of the rights of the exclusive licensee as such.
Isn't that just catering to the position that you may have an exclusive license that doesn't cover the entire scope of the patent? So the exclusive licensee has an exclusive license for some things, and the patentee retains their rights for other things. Insofar it falls within the rights of the exclusive licensee as such, his rights are infringed, and he's entitled by section 67.2 to damages or profits on
And
that,
in order to
those acts.
indeed, and in order to answer my lord's question, do I have the rights? One has to look at the agreement to determine that.
But that's not. The agreement doesn't need to say rights to damages, rights to profits. It's a question of what the scope of the license is. Is it an exclusive license? And if so, what is it that's exclusive license? And has there been an infringement of those exclusive rights? If there has, section 67.2 seems to me prima facie to give the exclusive licensee the right to damages or profits, subject, as my lords have discussed, to the ability of the parties to come to some other agreement by contract. But in the absence of any other agreement, that's what section 67.2 appears to do.
The problem with that is that what it assumes is that the creation of the exclusive license comes with it an agreement to give away a share of the profits that would come from any litigation.
Shall we continue this debate tomorrow, Mr. Hall? 10:30 tomorrow.
Should we sit at 10 maybe just to give
Yes. Would you prefer to sit at 10?
Yeah, it might be beneficial.
All right, we'll sit at 10.
We finish half an hour earlier then. So we,
10 o'clock tomorrow.